telling you that these respondents here, if they are going to be released, there'll be an issue of the mental state of the other witnesses. So, Yona, in a nutshell, this is what they're telling you are compelling reasons. Yona, how compelling are they for you? Article 49, they're the one they've come under. AG and H and I. What do they tell you? Once a suspect has been brought to court, the state must give you compelling reasons, which they have failed, and therefore, if they fail, what is the net effect, Your Honor? You must release the respondents. But then they try to modify it and tell you that, Your Honor, please hold these people in custody because it is for their own good, it is for their own safety. Let us start with that. In them saying that, have they shown you that these persons are in danger? Have they done that, Your Honor? No. Have they shown you anything from the respondents saying that we are in danger, please help us or protect us? Your Honor, again, no. So they cook up a story and tell you that these respondents are in danger out there so that they can convince you that it is better to keep them in custody. Your Honor, isn't that an imagination? If it was in social media, we would have said it's content creation. But in court here, what we needed was evidence. So what shows that they are in danger today? What shows? Nothing. Your Honor, Article 29, what does it say? That every person has a right to be safe, to be assured of security and their safety. So the same state stands here today and tells you that these people who they are supposed to protect are in danger. How do they contradict themselves and come before you? The same state that is supposed to protect these people, to assure them of safety out there, comes and tells you we cannot protect them. But Your Honor, our real danger is not even the people out there. Our real danger is the police officers. That is what we fear. Why am I saying this, Your Honor? These respondents, including the sister, who is an advocate of the High Court, were beaten by police officers. They were beaten. I went personally, Your Honor. I can swear upon this. I went personally. I spoke to the investigating officers. I pleaded with them. I implored them to take them for medical treatment. I spoke to the OCS in both stations that they were. These same officers who denied them treatment, are coming before you and telling you, please give us these people to go and do what? Beat them again? They are more in danger from the police than the public out there. Then the same police officers, after 2 days of requesting them, please take these people for treatment, what do? They send somebody unidentified in the middle of the night to Kibera police station to go and give some pills to the second respondent to take. The same people who are beating you are now bringing you a person. They call a doctor and giving you pills to take. Your Honor, we cannot take them. You cannot trust them. You cannot trust those pills. But they still want you to give them, these people, to stay with them for 30 days. Are they being honest? And yet they are telling you it is for fairness sake. The pills are here. We don't know what this is. They don't tell you that these are painkillers or anything. They just give you. They don't know whether you are allergic. We don't know who they are or agents of what kind of person that they are. But they are telling you, we are good people. Trust us. Give us these people. You know, these people might never come back alive. Not with these policemen. Not with these force that we are having. We cannot trust them. Yet we love them. Yet we think that they are not protect us. Then they tell you, to just switch in their story, that Your Honor, these people will interfere with witnesses in this case. Your Honor, today, do you have statements of any of the witnesses that they have recorded statements with? Who are they going to interfere with? You have not been given. They do not have statements because they are telling you we are going to record statements. But they are saying that the respondents know the suspects, the witnesses, so they are going to interfere. What are they telling you? They don't know the witnesses. We don't know the witnesses. How can we interfere with people that we do not know? Are they forgetting that there is a witness protection program that is guaranteed under the Constitution so that if they have witnesses, they can be protected by the state? You know, these fundamental rights have not just been created for the purpose of creation. They are created so that you protect these persons from these kind of state officers who are dangerous. The fundamental rights are not mere suggestions. They were put there for a reason. So that these people are not tortured, so that these people are not beaten, so that these people are not harassed. And then they tell you they are going to interfere with witnesses, but you want to let us now go deep. And then you're being told, and this is crafted in a way that you do not go deeper into it. In the case of Danstan Omari, there was actual interference and a complaint was brought to court and there was evidence that somebody had interfered with witnesses. Witness was brought to court. What have they brought here today? Is there a suggestion that they have even attempted to do so? No. But Danstan Omari says that you must bring material evidence to court. That's what the decision was based on. It is the same case that you have been told of Dwight Sagarai versus Republic. That was case number 61 of 2012, not 2013. The court said, and this was Justice Correll, she said quite clearly that for you to bring an issue about interference, you must place material before the court. Your Honor, the catchword being must. It's not an imagination, it's not a suggestion, it is a must. That is established law. So they can't come here and tell you we imagine. Your Honor, today, let us use facts because this is a court of law, not imagination. Your Honor, let us look at a similar case. Case number 48 of 2012. David Richard Alden versus Republic. Luckily, I'm in almost all these matters. In the case of David Richard Alden, Justice Lesita, as she then was, said one thing. You cannot come to court and say that there is interference because the sky will be the limit. Anybody can say anything. And they are saying anything. That is what they are doing today. So, Your Honor, because of an imagination that these people are going to interfere with witnesses, deny these people their rights? Your Honor, not today, please. They need to go back and read what the state said. But then again, they are trying to tell you that they will abscond. The real reason that now that the case is there, the case is strong again, is that they will run away. In the same two authorities that I have indicated, the court said that in case you want to suggest that somebody wants to abscond, you must also place material before the court. You must show that they have bought tickets, or they are prepared to travel, or they are speaking to travel agents. Have they done that today, Your Honor? They have not. But yet, they want you to go with the imagination they are giving you. Your Honor, today, please, let them go back and I say, to read the law. Then you're being told that there is public interest and the public is aware about this matter. This matter has become high profile. Your Honor, high profile how? In Oyamo versus Republic, that is case number 113 of 2018, it's a Court of Appeal decision from the Ovado case. What did the court say? You must also show the interest that you are saying. You must prove it. You cannot come and say it only, but also give it backing. But they want you to keep an old lady like this, who is 75 years old, 75 years old, and they forget that Article 57 says, treat them with dignity, not with the lies that the prosecution has been given by the investigating officers. That is not dignity. Dignity is to treat her the way she's supposed to be treated. And that must go with Article 28. It is inherent. You must treat all the people with the dignity they deserve, and Article 28 also says there is inherent dignity, which somebody must preserve for themselves. And that goes for the second respondent. Today, Your Honor, let me reveal, he is an advocate of the High Court. Luckily, he was Mr. Danstan Omari's classmate. Yes. So he is an advocate of the High Court. They forget one thing, again, Your Honor, let me just say it this way. They forget that he is running an office as an advocate. He is supposed to attend to clients. He has got cases coming up next week. And the two respondents have a matter related to this case that was mentioned to you that is coming up next week. But what do they want to do? Keep them in custody because they are in favor of the other side. I will stand here and say that that is what they want to do. And they know it. And they tell you that the respondents evicted the deceased from her property. It is not true. The affidavit says a long-standing case. Your Honor, this is a case for 2026. The eviction was by a court order, lawfully, supervised by the police. The case had been determined. The property belongs to the first respondent, not to the deceased. How do they cook up this story and imagine you will believe? If they want to come and get equity today, Your Honor, let them come with clean hands, not falsehoods. This is a court of law. The registration of the assault on these other respondents who are here could not be recorded. Why? Because it's a cartel of police officers. Any report against a police officer cannot be allowed. They will not. They went to the DCI Langata. I called personally and sent the advocate in court. But for these other persons, even in the stations, they refused to record it in the OB. So if the second respondent failed today, it's another Albert Ojong kind of case. But they will not. So, Your Honor, now that we have found out that their stories are not genuine and cannot hold water, they forget that this must come to Article 19. These fundamental rights are not for the police officers, are not for the state. They belong to the accused persons and suspects whenever they are apprehended by the police, so that they are protected. And the court is bound under Article 20 and 21. These inherent rights, these fundamental rights, once the court notices that they are there, the court must start by wanting to grant, not to deny, as the state will come with an affidavit to show you. So, Your Honor, while they say that they have now treated our client, right to treatment, Your Honor, does it exist? Yes. Right to medical services? Yes. So we are saying, Your Honor, while they want them to be investigated, please release this person so that they can also go for medical treatment. Not one that they have created from somebody we don't know. So that they can be treated. You can't go and tell somebody, we want to investigate you to write your statement when they are in pain, when they are in suffering, and you say that it is free will. It cannot be. Your Honor, now that they are refusing, activate Article 23. 23 says that now we can come to the court, because when they have refused, we come to the court. You are the arbiter. Now that we know that they don't want these people released, Your Honor, please help us. They don't have to be in custody to be investigated. They can report on a daily basis. These are family members who stay in the same house. They live together. This is mother and son. But they are being told, because some people used a motorcycle and they absconded, and they disappeared, that these people will help them to run away. The people have run away. The people were not found at the scene. But you're being told, please, these people know who they are. It is not true. But you're being told evidence is strong in this case, and therefore use that evidence to deny these persons to go home. Your Honor, Oyambo versus Republic, I am repeating. Court of Appeal, case number 113 of 2018. What did the court say about that? The evidence that is being brought to you and being told that they were identified, and that they were at the scene and they did all these things, Your Honor, cannot be brought into this court, cannot be tried at this particular stage, and therefore the truth cannot be determined at this particular moment. And the Court of Appeal said it is unfair to ever try to use that situation. Do they have a Court of Appeal decision higher than that? Let us not use an issue of what they call probability, because, Your Honor, the fundamental rights are as exact as they can be. They are not probabilities. You're being told, because there are multi-agencies that are being used, therefore, please give us 30 days. So what, Your Honor? Multi-agencies are who? They are officers like anybody else. Those multi-agency officers can go to and investigate what they are investigating. If they are dealing with data, whatever they are dealing with, they can go ahead and do it. It does not require 30 days. It does not require these people to be in custody. Now, I'll just mention, before I leave it to my colleagues, I'll go to paragraph 13 of the notice of motion, paragraph 13 and 14. And they're being told that the deceased, while she was driving on 7th of July, she was driving along Gong Road near Junction Mall, two unknown men, Your Honor, that is the caption. Two unknown men riding on a motorbike pointed a gun at her. She then ran away and filed a report. Identified as the second respondent. Identified by from 7th to 31st. Why have they arrested him for that issue? Why are they making it so dramatic now and bringing up an issue that does not exist? Where is that statement where she identified and mentioned that it was Chris who is here in court today, so that we have it and know that it is true? Your Honor, this cannot be true. And that on 27th, while driving from a homestead, she was trailed by unknown men. Your Honor, unknown, everything is unknown. So because some people who had a motorcycle had a gun, which has not been found with the second respondent, so they should carry the cross. Because the police are incompetent, they cannot investigate a matter from the 7th until today. If they cannot do such a simple matter of a threat from 7th until 31st, what are they asking 30 days for? They can do nothing. And I'm repeating again, please do not allow these respondents to go back to those policemen. They'll be beaten. It is given.
Counsel. Your Honor, Your Honor, I wish to associate my submissions to the good submissions made by my good friend with reference to this matter. Your Honor, all that I wish to add in this matter is that there is a violation of suspects' rights already. The suspects were arrested on Wednesday. Today is Friday, that's 6 hours down the line. And all that the IO or the prosecution is doing, Your Honor, is to perpetrate that illegality. Your Honor, this is a court of law, a court that cannot perpetrate an illegality. Your Honor, on paragraph 21, read together with paragraph 22 of the supporting affidavit, 21 of the supporting affidavit, together with paragraph 22, clearly states that the killers in the offense before this court are known. They are saying they were holding a pistol and there was a motorbike. Someone was riding a motorbike. That clearly exonerates the suspects before this court.